Leonard, welcome back to another episode of The Emily Show for Monday, May 11th, 2026. And I thought we were done with this case. We're not done, because all last week during stream, I'm like, hey, we saw joint statements about a settlement, and then no notice of settlement being filed, and then the notice of settlement. But it didn't stop there. We have got to talk about what is still going on in Blake Lively versus Wayfarer and what this even means, because I've seen not a lot of conversation about what the legal side of this is. There's a lot of other conversations, but today, my conversation is going to focus on the legal side. And then maybe, just maybe, this case will be done. It was supposed to be going to trial. Jury selection was supposed to be starting today. And that's not happening because, well, for most things, this case is done, but not for everything. But it's settled. I know. But everybody's still talking about it. I also know. There's some wild news about this case. And the things that are still outstanding, we've got to talk about. So let's talk some law. One thing on the docket today, because this week we've got a lot on schedule for stream. So make sure you have the Leonard app. There are things you are not going to want to miss, including my shirt. I know. What does it say, Emily? It says I'm with the band. We'll talk about it more later. You are going to want to have the Leonard app. We also have Corey Richens sentencing this week. Remember, the judge denied her motion to continue. So Corey Richens will be sentenced on May 13th, and we are going to be streaming it live. Let's get into this week's episode of The Emily Show. I'm legal analyst Emily D. Baker. Yes, also a lawyer. And this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. And Leonard, for those of you that have been following along with other sentencing, yes, we were supposed to have the Brendan Banfield sentencing on May 8th, International Leonard Cookie Day. Don't worry, we're doing an International Leonard Cookie Day, take 2, on June 5th, because that got continued. I know, but that's okay. We're still going to get it done before Judge A retires on July 1st. It's all going to be good. We will be back in Virginia in June, which is fine because May is already so incredibly busy. And all the filings in this case came down on like Dr. B's birthday and my birthday. And then I asked the Leonards, hey, do you guys want to cover this on stream? To which I received a resounding, do we have to? Please no. Why isn't this case over yet? So we're going to do some legal updates on the podcast because there is still legal stuff happening. But first, I want to talk just a little bit about some of the headlines you may have seen, because one of the big headlines as we got past Blake Lively's appearance at the Met Gala and the joint statement of settlement that I covered here as a case brief, we will link that down below. During that, I said, okay, well, maybe they've already signed an NDA, because why would you put out this joint statement if things weren't basically done? Well, maybe because of the Met Gala, but it seems that that joint statement was put out and maybe the details of the settlement weren't hammered out yet. And then we continue to see more information from the lawyers who are speaking publicly about this case. Blake Lively's lawyer was asked by ET last week about rumors that legal fees for Lively had topped $60 million. And while that was not denied, the statement was litigation's expensive. That's my summary. And that's true that litigation is expensive. And am I shocked by $60 million in legal fees for this case? No, not with this amount of docketed items, not with this amount of filings, not with the amount of work that went into this case and the depositions. They were up to essentially the eve of trial when this case finally settled. Well, there's one thing outstanding, but no, I am not shocked by that headline that the legal fees are estimated to be around $60 million. We also saw statements from one of Baldoni's lawyers, and I am saying Baldoni's lawyers. However, at this point, Baldoni and all of the other individuals aren't still in this case. The settlement is between Blake Lively and Wayfarer. And yes, Wayfarer is a corporate entity that is partly owned by Baldoni, but he as an individual and the other individuals that were sued are no longer in this case. They were all dismissed out of it. So the while actually side of Emily will try to keep saying Wayfarer, everyone kind of understands this case to be between Lively and Baldoni. We'll be using Baldoni when we are talking about, well, the lawyers, etc. So one of Baldoni's lawyers, Brian Friedman, has been giving quite a fair few of interviews. And one of the most staggering things we saw him say is that there's no NDA in this case. I don't know if I've ever really seen a negotiated settlement without an NDA. And my brain didn't even really process that when they put out the mutual settlement agreement, that wouldn't be the final word on this case, because why would you not have an NDA? Well, my thoughts on that, and of course, we don't fully know, but settling without an NDA indicates to me that settling short of trial was very much desired, and the agreement to not have an NDA, both parties thought was at least better than going to trial, and therefore agreed that there would be no NDA. So when I've said repeatedly, there's going to be an NDA in this case, and NDAs come with penalties, apparently not, which is a staggering thing in and of itself, but also indicates that not going to trial and potentially the cost of trial was a primary concern here. But when we're talking about lawyer costs, that's the last fight that's still remaining. We're going to talk about that fight a little bit, because we're going to see both lawyers in the media saying our side won, but settling this short of going to trial without an NDA means that the parties can still speak about this. And I imagine down the road, we will hear that at least from the Wayfarer Baldoni parties' sides. I don't know if we will hear that from Lively's side, because again, that could have happened at trial, and that is not happening at trial. So we are going to take a look at the notice of settlement that was finally filed in the court, and then we're going to take a look at the, hey, Your Honor, there's outstanding issues, and talk about what the legal side of the outstanding issue is. This was filed May 7th, 2026 in federal court in New York, Lively versus Wayfarer et al., Wayfarer versus Lively et al. Notice of settlement and joint stipulation pursuant to a settlement agreement and through their undersigned counsel, Blake Lively on the one hand and Wayfarer Studios LLC. It ends with Us Movie LLC, Justin Baldoni, Jamie Heath, Steve Sarowitz, the agency group PR LLC, Melissa Nathan, and Jennifer Abel on the other hand, the Wayfarer parties. Collectively, the stipulating parties hereby stipulate and agree as follows with respect to the cases. 1, the stipulating parties hereby irrevocably waive any appeal of any orders in the consolidated action, including without limitation any appeal by the Wayfarer parties of the order on the motion to dismiss. That is the Wayfarer parties' motion to dismiss. That means we are essentially seeing that the defamation case that was filed by the Wayfarer parties is also not going to be refiled. There's not going to be an appeal on that. The intention here is to put all of the issues now existing between the parties to finality. Everything except what's carved out next is going to be done. So any issue between these parties now existing, that doesn't forestall future issues, but any issues now existing are going to be included within this. And that's why the waiver of appeal, including the motion to dismiss, means that that cause of action, the countersuit, the defamation suit filed against Lively and Ryan Reynolds, will not be appealed and will not spring forth again. They go on to say, notwithstanding anything herein to the contrary, the stipulating parties acknowledge and agree that Blake Lively does not release and retains all claims, rights, and remedies in connection with her pending motion for attorney's fees, treble damages, and punitive damages under California Code Section 47.1 in the Wayfarer action. The stipulating parties agree that the 47.1 motion is not withdrawn and remains pending before this court. The stipulating parties further agree that they hereby irrevocably waive any appeal from the court's determination of the 47.1 motion. Emily, what's a 47.1 motion? Don't worry, we're going to cover it. We're going to get there. They go on to then say the Lively action is dismissed with prejudice as between the stipulating parties pursuant to Federal Rules of Civil Procedure 41A1A12. May 7th, 2026, signatures to follow. Lively is dismissing her claim with prejudice, meaning it will not come back. The Baldoni Wayfarer counterclaim was dismissed by the court with leave to amend as to some of the causes of action. Not all, but some of the causes of action. They're waiving their right to appeal that, which means that is essentially also dismissed with prejudice, but you can't dismiss it with prejudice because it's not now existing on the docket because it's been dismissed. Hopefully that makes sense. But waiving the appeal essentially accounts for the same thing. What does this mean, though, that Lively does not release this one docketed item? Well, this motion regarding 47.1 damages is still pending on the docket, has been on the docket for quite some time. That motion was originally filed back in September 2025 for attorney's fees, treble damages, punitive damages under California Code Section 47.1. I'm going to link the entirety of that code section down below if you want to go take a look at it. But in the letters that are following, it will also discuss this code section, and we will discuss what it means. Of interesting note to me, this is a newer code section that went into effect January 1st, 2024. Remember, Lively's complaint here was filed December 31st, 2024. But you're probably remembering, because you're a law nerd and you are very intelligent, you are remembering that the judge had a huge issue with applying California law in this case. And that was a central part of the motion for summary judgment, and that some of the claims couldn't be brought because contractor versus employee. But applying California law when there was not a choice of law provision and the movie was filmed largely in New Jersey, and so the action didn't happen in California, well, is that going to be a hurdle here as well? Could the judge just say that Section 47.1, a California Civil Code section, does not extend to a counterclaim filed in New York court regarding a movie that largely filmed in New Jersey? The flip side of that is that the company Wayfarer is a California corporation, and that section deals with speech more than it deals with the underlying actions of what happened. The court found that the actions that were being complained about happened on set. Set was not in California. But when we are looking at speech, the judge might evaluate this differently. So we will get into it as we get into the following letters, because Lively's lawyers also explained this more in their letter to the court that was responded to by the Wayfarer parties. Leonard, a quick thank you to our sponsor, Oneskin. You know, one of the things I struggle with is time and even perceiving that it's changing. And so one of the areas that I never have enough time is makeup, prep, skincare, and Oneskin's got that handled, because truly my face routine with Oneskin is just Oneskin face. And then if I need it, the eye cream, but Oneskin face. They've also got you covered for body, for scalp. And you'll notice lately I've been trying to get the little baby hairs down in the bun because I'm actually seeing a substantial amount of new growth in my hairline. And who doesn't love that? Plus, Oneskin's results are backed by 4 peer-reviewed clinical studies, over 10,000 5-star reviews, and they've been recognized by Bloomberg as a leader in skin longevity. You really don't need a complicated routine to get healthier, younger looking skin. Oneskin's OS1 peptide is born from over a decade of longevity research, and it's proven to target the visible signs of aging, helping you unlock your healthiest skin now and as you age. So for a limited time, Leonard, you can try Oneskin at 15% off using code Leonard at oneskin.co/Leonard. That's 15% off oneskin.co with code Leonard. And after you purchase, if they ask how you heard about them, let them know it was the Emily Show. And now let's get back to it. The letter that we're looking at from Lively's attorneys is also from May 7th, 2026. Dear Judge Lyman, as the court is aware, plaintiff and consolidated defendant Blake Lively, that's because there was a counterclaim. On the one hand, and the defendant, the agency group PR, the defendants and consolidated plaintiffs, Wayfarer Studios, everybody, all the Wayfarer parties, on the other hand, have executed a settlement agreement resolving nearly all claims pending in the consolidated action as captioned above. As reflected in the notice of settlement and joint stipulation filed earlier today, the parties have fully and finally resolved all claims except one. The only remaining claim is Lively's claim for attorney's fees and cost, compensatory damages, automatically tripled by statute. That's the treble damages, like double toil and trouble. No, Emily, triple damages. Treble damages are triple damages Remember, we look at compensatory damages, which are the compensation for things that happened, monies that were spent, etc. Punitive damages are those punishment damages where it's like, hey, you suck. We don't want you to do this anymore. So we're going to find a bunch of money so that maybe you won't do it again. Punitive damages, punishment damages, compensatory damages, compensation, treble damages, triple. Hopefully that helps with the law nerd translation of legal. So the motion from Lively is for attorney's fees and costs, compensatory damages, which are automatically tripled, punitive damages, all under California Code Section 47.1, which the parties have submitted to this court to adjudicate with no right of appeal. Section 47.1 imposes severe and mandatory penalties against any party who files unsuccessful retaliatory defamation actions against sexual harassment and retaliation complaints. This is not the same as an anti-SLAPP action. This is a separate statute that California enacted in 2024 regarding protecting complaints made about sexual harassment and retaliation. Not just sexual harassment. And remember, in this case, the causes of action that were going forward to jury before this settled were retaliation claims. The lawyers go on to say that under Section 47.1, any, quote, communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination, including retaliation, is privileged so long as the speaker has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. That is a broad statute that says if you have the right to file a complaint, even if you don't, and you communicate without malice, malice not meaning vibes maliciousness, malice meaning actual knowledge of falsity, which is something we talk about in this context when looking at defamation against public figures. This is the same type of malice in that defamatory concept, not vibes. I know, like hostile witness, not vibes on hostility, maliciousness, etc. Legal sense of the word malice, meaning knowledge of falsity or reckless disregard. And that covers sexual assault, harassment, discrimination, including retaliation, whether or not a complaint is filed, which means we can end up with the court now having to determine if a communication was made, if it was made without malice, if the speaker, in this case Lively, had a reasonable basis to file a complaint, not having to determine whether or not a complaint was filed, even though one was here. If that happens, then if there is a defamation suit arising out of those claims, then it can trigger this statute that allows for attorney's fees, treble damages, etc. So we can end up right back in a factual dispute if the court finds that this law applies in this case and can be applied in this case. Speaking is going to be evaluated differently than actions taken on the set. And the court can look at that complaint and that communication being made in the extension to the contract that was in fact signed, even though that did not have a choice of law provision. So whether or not the judge finds that this section applies to this case in this court will be interesting. And no matter what the court does, nobody has the right to appeal it. They go on to give their interpretation of what this law stands for, saying that it was designed to ensure that individuals subject to harassment retaliation can share their experiences with courts, agencies, the press, and others without fear of suit. The California legislature enacted this privilege to provide a clear, unambiguous path to justice for victims of sexual assault, harassment, discrimination. Specifically, they say the California legislature intended for the section to deter litigation that would otherwise force survivors to defend against long and expensive retaliatory defamation by imposing, quote, significant remedies for successful defendants in defamation claims. So the court's also going to have to evaluate if the motion to dismiss counts for them under this section as successful in a defamation claim. And the court can, because the court dismissed it, the other party chose not to file it. It will be interesting to see how the court navigates that. How the California legislature decided this was needed in addition to the California anti-SLAPP is probably a conversation for another day, but this steps in front of that anti-SLAPP statute and can cut off litigation sooner than an anti-SLAPP statute might, and provides more penalties than the anti-SLAPP in California. For those of you that have not heard me talk about anti-SLAPP before, that is the motions that are set to end retaliatory lawsuits, especially in the realm of defamation. When people are engaging in essentially public participation, they crafted that as a way to cut off the lawsuits even before you get into the expense of discovery. And SLAPP does stand for strategic litigation against public participation. So if somebody has an expose book coming out and then gets signed for defamation to try to push the book from coming out, it fast tracks that lawsuit. So that is what anti-SLAPP stands for and where those are used. This is a different code section and a different mechanism under the law. They go on to say that, moreover, because Section 47.1 protects victims from the litigation itself, these remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. It'll be interesting if the court finds that when the defamation suit is a countersuit, not a suit that was filed standalone on its own, whether this applies in that context. I don't know the case law, if there is case law yet, because this is a fairly new code section, how the court's going to navigate whether or not this is intended to protect those from speaking and then getting sued, or if it applies in the context where there's a lawsuit and then a countersuit. I think there's some nuance there that's going to have to be evaluated by the court, whether or not it applies again in this circumstance for that reason. The attorneys go on to say that no doubt remains that the Wayfarer party's suit is the prototypical suit that the California legislature intended to short circuit by enacting the lawsuit. I'm curious, again, that is their reading of the law, but the Wayfarer parties did not file this as a lawsuit after Lively complained to production or to Sony or to anyone. This didn't come until after she had filed suit. So I'm very interested in how the court navigates that, because that's a question that I don't think can be overlooked. They go on to say that the alleged defamatory statements that form the basis of the Wayfarer party's retaliatory lawsuit satisfy all elements of privilege under Section 47.1 for reasons that have already been raised to this court, footnote 2. Thus, they say, as the, quote, prevailing defendant, Ms. Lively is entitled to not just attorney's fees and costs, but also to compensatory damages tripled and punitive damages. They say that the parties briefed this issue previously, with said briefing completed as of September 29, 2025. Those briefs included proposed procedures for determining the damages, attorney's fees, and costs to which Ms. Lively is entitled. And again, that should cut off when the countersuit was dismissed. So when the court dismissed the Wayfarer party's countersuit against Lively back in June 2025, if the court finds this applies, that the remedies here are appropriate, if they find that, it would cut off at the costs incurred up until then, not all the litigation from June 2025 to May 2026. Continuing on, they say that because the factual record has developed further since that time up until the eve of trial, Ms. Lively respectfully requests leave to file a short supplemental brief of 5 pages or fewer to address any impact of the court's intervening rulings. I don't understand why they would need to brief this, because as I see it, all of the impact remedies, attorney's fees would end at the dismissal. And this was already filed and briefed in September 2025 after the June dismissal. In fact, they brought it because of the June dismissal. So it would seem to me that it's fully briefed, and everything that happened after the dismissal doesn't impact this motion because it would stop there. But they are asking for leave to brief 5 more pages. If they do, let me know if you're curious about what they say in this motion. I'm interested in the legal nuances here and whether the court will take this up, whether the court will kick this on this law doesn't apply to this action. I'm curious how this gets navigated because we have seen Judge Lyman be incredibly thoughtful and diligent in his navigating case law, and I'm legally quite curious here. They go on to say that the motion was filed and to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and cost in light of these developments. I don't think they get everything in light of the developments. I don't think you get attorney's fees for continuing to litigate your side of the lawsuit after the suit that would or could entitle you to these fees has been dismissed. So no, I don't think you get additional briefing, but we'll see what the court says. Let's take a look at the reply. Lawnard, a quick thank you to today's sponsor, Daily Look. And if you're like me, it is now the time of the year where you have too much to do, not enough time, and you're looking in your wardrobe going, what am I going to wear to all of the variety of things that are going on with my kids? And if you find yourself there too, looking at your closet going, what even am I going to wear? Our sponsor, Daily Look, has you covered. Daily Look is the #1 highest rated premium styling service for women. With Daily Look, you get your own dedicated personal stylist to curate a box of clothes based on your body shape, preferences, and lifestyle, not based on an algorithm. You can try on up to 12 premium pieces per box, and you can let them know how much you would like to spend per piece. So you're saving time, you're saving effort, and things that go together are just being delivered to your door like your own personal curated capsule wardrobe. I have really enjoyed my Daily Look boxes, and if a size isn't quite right or I want to swap something out, it's really easy to do that. Daily Look also runs from extra small to 3X, and they've got sizes 0 to 24. So you are going to find something for most bodies, which we love. So it's time to get your own personal stylist with dailylook.com. Head to dailylook.com to take your style quiz and use code LAWNERD for 50% off your first order. Once again, that's dailylook.com for 50% off your first order with code LAWNERD. One last time, dailylook.com with promo code LAWNERD. Now, let's get back to today's episode. The attorneys for the Wayfarer parties replied on May 8th, 2026, saying, quote, after agreeing to a settlement in which she dismissed her 3 remaining claims without the Wayfarer parties paying a cent of the $300 million in damages she was demanding, plaintiff Blake Lively seeks leave to submit further briefing, quote, to address any impact of the court's intervening rulings since the 47.1 motion was filed and to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, cost in light of these, which we just read. They go on to cite 47.1b saying that, quote, a prevailing defendant in any defamation action brought against that defendant for making a communication that is privileged under this section shall be entitled for their reasonable attorney's fees and costs for successfully defending themselves in the litigation, plus treble damages for any harm caused to them by the defamation action against them, in addition to punitive damages available under Section 3294 and any other relief that may be justified by law. They go on in a footnote to say that they believe that the plaintiff mischaracterizes the stipulation with respect to protected activity because they had stipulated that for the purposes of trial, the complaints that Lively made did count as protected activity and that the jury could then presume that, but that was a for trial only stipulation, which they note in the footnote. They go on to say that the plaintiffs initially sought remedies under 47.1 in a March 2025 motion to dismiss Wayfarer's complaint filed in response to Lively's complaint for, among other things, sexual harassment. On June 9th, 2025, the court granted plaintiff's motion dismissing the Wayfarer complaint, including Wayfarer's second cause of action for defamation against Lively. They say that the court denied plaintiff's 47.1 request without prejudice, and plaintiff renewed the motion on September 8th, 2025. The renewed motion was fully briefed by September 29th. In her April 11th, 2026 pretrial statement, Lively submitted that the 47.1 motion should be decided in advance of trial and renewed the request that, if granted, the court should set a schedule to promptly quantify the monetary award. They go on to say that Lively at that time did not request or even suggest that additional briefing was necessary. I suggest because it's not. Honestly, if this court wanted additional briefing, the court would ask for it. They go on to say that at the April 28th, 2026 pretrial conference, plaintiff again urged the court to decide the motion before trial, and if the court found that plaintiff qualified for That's the note. That's the note that I was waiting for. If the court found that plaintiff qualified, because we're not at this is a given. I see that this is not a clear path forward on whether or not this qualifies. I don't think that that's a yes, this qualifies. Let's determine how much it is. If plaintiff qualifies is a big question here to me. They go on to say that if the court found that plaintiff qualified for relief under section 47.1, then the jury should be instructed that defendant's lawsuit constitutes retaliation. Well, I don't think those things follow. And then it would be up to the jury to determine whether that caused any damages. They go on to say in plaintiff's briefing that plaintiff explained that the legal question of whether the lawsuit that the defendants filed was retaliatory is one that is before the court and the court can decide, and we wouldn't have to take evidence on it. It's a fair point as to why would you need additional briefing. They say that plaintiff does not explain why. A week later, she believes supplemental briefing is necessary. They go on to say that plaintiff does not give any insight into the potential impact of post-dismissal rulings or developments, nor does plaintiff enlighten on how rulings subsequent to dismissal could possibly impact or increase the cost to defend the dismissed claim. That's how I see it too. It seems to me that the dismissal closes the gate on further damages because the purpose of the law is to compensate someone who is fighting as a defendant a defamation claim for bringing to light a certain category of activity. So speech regarding a particular subsect of activity, if sued for defamation based on that speech, then if successful against that defamation, then this is the compensation mechanism that is triggered. But you have to be victorious, and then anything after that victory isn't contemplated by the statute. Right. I don't see how that would go otherwise, truly. They go on to say, and of course, plaintiff fails to explain why the court, which authorized the subsequent rulings, would need additional information to determine their impact on remedies that may be available to a defense completed no later than June 9th, 2025. Simply put, plaintiff does not explain how her right to relief under section 47.1 could be affected by subsequent rulings. I agree. Agreed. They go on to say the Wayfarer defendants respectfully request the court deny plaintiff's request for further briefing, an evidentiary hearing, or other proceedings on whether plaintiff is entitled to recovery. They are essentially saying, you have all the rulings, you can rule on this. We've waived appeal on it. You can go ahead and rule on it. It's fully briefed. I agree with the Wayfarer parties here. I don't see how subsequent rulings impact this. So where does this leave this settlement? Well, seemingly without an NDA, which is wild to me, but if the goal here was to stop this litigation short of trial, that might have been the only way it was agreed to. So it seems that we are without an NDA, that there is still this fairly nuanced fight on attorney's fees, but that's not all attorney's fees. I do think the fight on attorney's fees here, if this is available to the court, then it cuts off on the date of the dismissal of the counterclaim. I'm very interested legally to see what the court does with this fight on attorney's fees, compensatory damages, and punitive damages, because the court is going to have to then walk through, if they find this law applies, then if everything in this law applies, then what those damages are. Let me know if you're curious to see how this continues to play out, or if you're just like, they settled, are we done? It seems that we're not, which is unusual. Normally it's a notice of settlements, we need 30 days and then everything's done. But did you also catch what they put in this motion? There was one really interesting note that the settlement was agreed upon without Wayfarer defendants paying a cent. So when asked what's in this settlement and if we're ever going to know, a week ago, I was like, we're probably never going to know what's in this settlement. It can be a lot of things. It can be monetary. It cannot be monetary. It can be a mutual walkaway, like, hey, we're not pursuing any claims against you. You're not pursuing any claims against us. We all take our lawyers' fees and go home. But we have bits and insights of more clarification. And with no NDA, I don't know if all the terms of the settlement are going to be secret forever and ever, or if we're going to keep seeing these little hints of what might be in the settlement. But we at least have the answer. One, no money has changed hands, or at least the Wayfarer defendants have not paid any funds. Two, Lively spent at least $60 million on attorney's fees, probably same for Wayfarer, if not more. And there's no NDA, according to one of the attorneys, and I've not seen any statements pushing back on that. If you see them, please let me know, because I am very curious. But we've now seen Lively's attorney and the Wayfarer party's attorney speaking about this settlement, and we haven't seen pushback. And these attorneys have been fast to correct each other. So I'm inclined to think, beyond all belief, that we have a settlement of an incredibly contentious and high-profile civil litigation with no NDA, which means it probably doesn't actually end with settlement, and we are going to continue hearing about this. Let me know if you're curious about the law behind all the lawyers' fees and how the court navigates this 47.1 application, which I think is going to be a really interesting legal question about if that even applies to this type of case, because it seems that the legislative intent here was that if somebody made a complaint or even went to the media and then was sued for defamation, that they have some remedies. I don't know if a cross complaint is going to loop into that. Let me know if you're curious to follow the legal side of the, well, maybe it never ends. And we are continue to be locked in to this litigation for at least a while to come. Law Nerds, it's good to see you. I will see you this week on stream. Make sure you get the Law Nerd app. Take care of yourself. Take care of each other. And I will be back in the next one. Cheers. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.